The government's announced a raft of law changes it says will make the justice system fairer and safer for victims of sexual violence. The changes would mean a complainant may never have to set foot in court to give their evidence or face questions from the defence. It would be their automatic right to pre-record both to be played in court later. Judges will have to intervene if questions are considered unfair or inappropriate, and the rules around evidence about complainants' sexual history will also get stricter. I asked Justice Under-Secretary Jan Logie which of the proposed law changes she thinks would make the biggest difference to complainants in sexual violence cases.
I'm not actually sure I can identify that, because we've heard from survivors, and I can point out a couple, that and I think the ability to pre-record their evidence so that they don't have to keep holding that story or necessarily turn up and talk about, one of the worst experiences of their lives in really intimate detail in front of a room full of strangers. I think that's going to make a significant difference, and we've been told from survivors that at the moment is really problematic. The other thing is the directing judges to intervene when they see inappropriate questioning, and enabling them to develop directions to counter rape, myths around sexual violence, will make a difference in terms of the quality of evidence, so that we're actually testing the defence on the basis of what's real, rather than confusion and misapprehensions.
Let's look specifically at the recording of evidence, right? So it would be not only recording the complainant's evidence in chief, but also pre-recording the defence's cross-examination. Now, why is that needed? Because a judge can close a court, they can allow evidence to be heard from behind a screen. They've already got mechanisms to try and reduce the trauma.
So they can use those, but at the moment, so adults have to apply for that rather than it being an entitlement. And there are very few cases where that cross-examination happens in a pre-record, which means, and we know from complainants and survivors who have gone through the process, that that is what they dread the most. And if we can enable that to happen earlier and outside of the theatre of the court, the overseas evidence is that actually it doesn't compromise the right to fair trial, but it does significantly reduce the trauma of the process.
You'll be aware, obviously, that some defence lawyers in New Zealand do not agree with that. They think that it raises some issues with the cross-examination being pre-recorded. The jury doesn't get to see that take place in front of their eyes. You and me sitting here talking to each other. I look at your body language, I assess your credibility. All of that is part of the discussion. You're taking that away from a jury, is what some defence lawyers would say. Is that fair?
No, it's not. I understand the concern, and but when this was tested, so in Australia, they tested it in a state to see if it did compromise that right to a fair trial, because that's our primary concern, right? Is doing everything we can to reduce the trauma while preserving that right to a fair trial, because we don't want anyone unfairly convicted. So they tested that and they found that it didn't. Pre-record did not compromise the right to fair trial, and then they rolled it out in the rest of the country.
On what? The number of convictions?
From the experience of feedback in the place of the parties involved. And the truth is, New Zealand, these changes are getting us to catch up with international best practice. We're not leading the way. This has been tested in other jurisdictions. And I also recognise that the defence, they have concerns about that I have confidence we're going to be able to work out in drafting of it about the timing of
because
when
it could be
evidence is given.
outdated. A cross-examination could be superseded by new evidence, another witness who says something else.
Yeah.
And in fact, isn't it possible that it would actually counter everything you're trying to achieve? That person may have to give evidence more than once as a consequence of pre-recording.
Well, that would still, the primary evidence that they'd given and the cross-examination would still hold. They wouldn't have to repeat any of that, but you'd be able to add on to it. But I do think that we will be working really closely with the profession to draft the legislation to take those concerns into account, and I'm really confident we can do it.
A lot of this is about, and your press release says, this is about ensuring fairness and safety for victims of sexual violence. This question may make some people uncomfortable, but by using the word victim, you're presupposing a position, aren't you?
Yes.
And some people would argue that there is sympathy for people who present in court as the victim versus the defendant. So there is an imbalance already, is the argument.
In the court process, primarily they will be described as a complainant, and we're not changing that in the legislation. However, when the evidence has been that we've had about a 1% conviction rate relative to the prevalence of this violence in our society, I think it's okay to talk in this context about victims, because we know we are failing to get the convictions, and a lot of that is about the confidence in the system for people to report.
Some of the things that you have not done but you're going to continue to look at, so that resolution service was one of them, right? And another one is to potentially move away from juries in sexual violence cases in favour of judges alone. Where is the justification for that when it is a significant part of our culture to be judged by your peers?
Sure. And so we're not at an end point of saying yes or no to any of these.
But you're
we're
still
really
going down that
investigating.
road.
Absolutely, because one, there's again a body of academic research that has said that this needs further investigation, has put it up as a solution. Other jurisdictions have done it. It came out of the Victims Hui, organised by the Chief Victims Advisor not long ago, a very strong call for judge-alone trials with specialist advisors. And we also know that a judge-alone trial doesn't automatically resolve the concerns of victims, and that we really, if we're going to do that, it is a big call. So we have to be really sure that it's going to deliver the benefits and still ensure that balance, and that we have the mandate from the country to do that if we need to.
That was Jan Logie, and those law changes will be introduced later this year.